there was at least another email address. I know that it went home, so I wonder if it went to the wrong person.
What day was it? It was about spam posting. Yeah.
What day? Can you tell what day he emailed it?
No, I don't think that is the email. It was about 3 or 4 weeks ago.
Can you look and see what the date was?
From my office.
I
don't know if it's going to show.
All right. Well, obviously, I'm going to need a minute to go through all this. He can go back for a few minutes or have a seat.
They can bring back a house. Value.
This is discovery stuff. Some of this is. I don't think he wants to hand me all of this.
I got to look at it. Somebody else should have to look at it.
I don't know what that didn't have anything to do with what I need to look at.
It's right there. Some spinal time. I think there's a TDC show. That's a vision. Yeah. Shouldn't be driving.
Let's go ahead and get him back out.
Did you catch what the prosecutor just said there? That's one of the harshest things a court can hear during sentencing. That prison was the only thing stopping someone from committing more crimes. At that point, the argument shifts from rehabilitation to public safety. And when prosecutors mention a long criminal history stretching back to juvenile years, they're building a picture for the judge that this isn't a one-time mistake, it's a pattern. The real question is, after this many chances, should the system still prioritize rehabilitation? Or is protecting the public the bigger priority now?
You can summarize for me as well. That's okay. Nothing. I don't know. I mean, I guess it needs to be in the file. If it's something I've reviewed, it needs to be attached where the PSI is or something, please.
I mean, that's usually what I do. Submit additions to the PSI's email.
It was just with the. Sounds like it wasn't like.
Sorry. So you found it?
Yeah.
Okay. Discovery. Yeah, with my discovery certification.
Okay, you're Floyd Torin, and this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report. And the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torin's mental health as well as some physical issues. And one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am. Yes,
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Torin has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spinal Tap MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
We're waiting on the
We're waiting on this.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, is the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and cap this at 20 years. So we would ask for a TDC sentence in the high range on this.
So, Mr. Torin, in 2019, you received a 15-year sentence. So you were only, I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously. So you got out in 2023.
Wow. Judge West just completely dismantled the defense mitigation argument. Notice how she acknowledged the mental health struggles, the addiction, even the family support, but then immediately brought it back to personal accountability. That's a major theme in sentencing hearings like this. Judges will often recognize trauma or addiction, but the defendant keeps reoffending after repeated opportunities. Sympathy starts running out fast. And honestly, when the judge says, your only time clean is when you're in custody, you can already feel where the sentence is heading.
You've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you, as a grown man, have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. Your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know. I just think it's I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs, and it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and this evading was crazy. You could have killed people. You got used. I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. It's not like you just kind of sort of evaded. Your behavior is just a danger to everybody here in Jefferson County. So that being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. And cause number 25 DCCR 115.
This is the moment the evading charge stops sounding like a car chase and starts sounding like a potential tragedy, almost striking multiple vehicles, crashing through a fence, fleeing again after the crash. Judges take that extremely seriously because innocent people could have died. And here's something viewers may not realize. In Texas, using a vehicle during evading can dramatically increase the severity of the charge. So even though nobody was killed, the court is sentencing based on the danger created, not just the final outcome. Do you think 20 years is justified for this kind of reckless flight?
To find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, you can go back with the bailiff. Yes, sir. So Jaden Worlds. And Mr. Parker, will your client waive the formal reading of the indictments and the motions in each case? Mr. Worlds, in cause number 26, DCCR 0361, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from January 21st of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then
Notice how quickly the courtroom transitions from one serious offender to another. That's something people don't often see in these dockets. Judges can go from sentencing a repeat felony offender to handling an aggravated robbery case within seconds. But the energy changes immediately when you hear terms like deadly weapon and first-degree felony. Those phrases carry massive weight in Texas courts. Once firearms enter the picture, the stakes skyrocket for everyone involved.
DCR 0415. Mini button. You're charged with a first-degree felony offense of aggravated robbery, and that's from January 27th of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In each of these cases, those two cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each of those cases. It's admitted in each case. Is there any evidence that Mr. Worlds is not competent?
No, Your Honor.
All right, sir. In cause number 26, DCCR 0361, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding in that case of a deadly weapon. And cause number 26 DCCR 0415, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 20 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm also making an affirmative finding in that case of a deadly weapon. Now, in cause number 24 DCCR 1721, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation October 8th of 2024 for the state jail felony offense of unauthorized use of a motor vehicle, and that was a 5-year deferred probation. Is that correct? And then in cause number 24 DCCR 1420, I also have a motion to revoke your unadjudicated probation. This shows you were placed on probation October 8th of 2024 for evading arrest or detention with the motor vehicle.
That affirmative finding of a deadly weapon is a huge detail. It's not just courtroom language. It can affect parole eligibility and how much actual time the defendant serves. A lot of viewers hear the sentence number and assume that's all that matters, but enhancements in deadly weapon findings can completely change the reality behind the scenes. And look how calm the defendant remains here. Meanwhile, the legal consequences just became much heavier than they may sound on paper.
Third-degree felony. That was also a 5-year deferred probation. Is that also correct? Each of these cases allege that you have violated your probations. Count 1 in each case alleges that you committed that new offense of aggravated assault with a deadly weapon January 21st of 2026, the one that we just went through. Is that true or not true?
Judge, to save time, lead to count 5, count 7 in both of those motions. I don't think that in the rest if it's sufficient.
They're different. The motions are different. I'm not sure if that matters.
But if those are the same counts,
There's not a
same allegations.
there's not a count 7 in 1721.
1420, there's a count 7.
Correct.
Count 5 in the other one. It's the same as count 7.
So 5 in one case, 7 in the other.
Yes, Judge.
So in cause number 24 DCCR 1721, it also alleges in count 5 that you possessed and used a firearm, namely a handgun, to fire shots at 2 people on January 21st of 2026. And is that true or not true? And then in cause number 24 DCCR 1420, count 7 in that case also alleges that same violation of firing the handgun. Is that true or not true? All right. So did you enter your pleas of true to counts 1 and 7 in 1420 and 1 and 5 in 1721 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have also here on the tablet some documents in those 2 cases that have your signature on them that the
All 4 cases running concurrently may sound like a break, but make no mistake, this is still a devastating outcome. The defendant went from deferred probation in 2024 to multiple violent felony convictions by 2026. That's exactly why judges often treat probation violations tied to violent crimes so severely. Deferred adjudication is basically the court saying, prove you can stay out of trouble. And once new violent offenses happen, especially involving firearms, that second chance disappears almost instantly. One bad decision can derail a future. But repeated violent decisions? That's when courts stop gambling on rehabilitation altogether.
states marked as Exhibit 1. Did you also go over these with Mr. Parker? And do you understand them as well? And you also understand if I follow these agreements, you'll be waiving or giving up any right to appeal. State tenders number 1 in each of those cases.
Objection.
It's admitted. All right, Mr. Worlds, in cause number 24, DCCR 1721, find that you entered those pleas to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1. Hold on, I just pulled the wrong one up. I looked at the wrong thing. What's the agreement on?
2 years TDC and 2
2
years
TDC.
state jail.
Gotcha. So in cause number 24 DCCR 1420, also find that you entered your pleas of true freely and voluntarily. Find counts 1 and 7 true. Find sufficient evidence at this time to find you guilty, and find you guilty of evading arrest or detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. In all of these cases, I'm going to hand you the trial court certifications that shows that these were agreements that I followed, and so you have waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Here you go. Hey. All right. Thanks, Judge. See y'all later.